Can everyone hear me okay? First of all, thank you for the kind introduction, Mark. I'd like to thank Mark Fischler, members of the Sonora Lecture Committee, and Assistant Provost Ann Thurston for inviting me to Plymouth State University to deliver this year's Sonora Lecture. It's nice to get out of Orlando, where the temperature has been in the low 80s, and come to New Hampshire, where the weather is certainly more refreshing. This is my first trip to New Hampshire, and I'm glad to be here. The title of my lecture is, Why Do We Need the Death Penalty? For many people, the question may seem silly because many people take it for granted that we need the death penalty. After all, the death penalty is an ancient practice that has survived for millennia. I will begin my lecture by considering the death penalty in historical and geographical context. Then I will critically examine the reasons that death penalty proponents proffer for retaining the death penalty. And I will conclude by considering reasons death penalty opponents give for abolishing the death penalty. Prior to 1863, no country in the world had abolished the death penalty. By the beginning of the 20th century, only 3 countries had abolished the death penalty for all crimes. Venezuela was the first in 1863. San Marino was the second in 1865. And Costa Rica was the third in 1877. By 1977, only 16 countries had abolished the death penalty for all crimes. However, as of January 1st, 2010, 95 countries had abolished the death penalty for all crimes, represented by the countries in blue on the map. Another 9 countries had abolished the death penalty for all but exceptional crimes, such as those committed during wartime. Those countries are represented in yellow on the map. And 35 countries had abolished it in practice. That is, they retained the death penalty, but had not carried out an execution for at least 10 years, and are believed to have a policy or established practice of not using the death penalty. Those are the countries represented in green. More than 50 countries have abolished the death penalty just since 1990. Since 1985, only 4 abolitionist countries have reintroduced the death penalty. 2 of those countries, Nepal and the Philippines, have since abolished it again. And the 2 other countries, Gambia and Papua New Guinea, have not executed anyone since reintroducing the death penalty. Currently, more than 70% of the countries in the world, 139 of them, have abolished the death penalty in law or practice. Only 58 countries have retained the death penalty, and those countries are represented in red on the map. Still, the number of countries that actually execute anyone in a given year is much smaller. In 2009, the last year for which data are available, there were at least 712 executions in 18 countries around the world, and about 2,000 death sentences in 56 countries. Now, this does not count China, which does not report death sentences or executions, but is believed to have sentenced and executed thousands. Of the 712 known executions that took place in 2009, 92% were carried out in just 5 countries. 54% of them were carried out in Iran, 17% in Iraq, 10% in Saudi Arabia, 7% in the United States, and 4% in Yemen. Now think about it for a moment. Think about the nations that we're included with. If you examine the world maps of the executed countries I just showed you, you will have noticed that the entire United States is considered a retentionist country. However, that is not the case. In the United States, only 36 jurisdictions have a death penalty. 34 states, the U.S. government, and the U.S. military. 17 jurisdictions do not have a death penalty. 16 states and the District of Columbia. The latest states to abolish their death penalties are New Jersey, which abolished its death penalty in 2007, New Mexico, which abolished its death penalty in 2009, and Illinois, which abolished its death penalty on March 9th of this year. Not only has the number of death penalty jurisdictions in the United States been declining of late, but also so has the number of death sentences imposed. Prior to 2010, the number of death sentences imposed had declined in each of the past 8 years. In 1996, 315 people were sentenced to death, the highest number since 1977. In 2002, the number was about half as many, at 166. In 2003, it was 152. In 2004, it was 140. In 2005, it was 139. In 2006, it was 123. In 2007, it was 120. In 2008, it was 119. And in 2009, it was 112. The estimated number of death sentences in 2010 was 114, only 2 more than the year before. A recent study found that only 10% of U.S. counties accounted for all death sentences imposed between 2004 and 2009. And only 5% of U.S. counties accounted for all death sentences imposed between 2007 and 2009. The researchers reported that the concentration of death sentences in those countries was not a function of the heinousness of the murders committed or the incorrigibility of the offenders. Rather, in some counties, prosecutors sought the death penalty, and in other counties in the same state, they did not, even for the same or more aggravated death-eligible murders. As of March 10th of this year, there have been 1,243 executions in the United States since executions resumed in 1977. When I say since executions resumed in 1977, I am referring to the hiatus in executions between 1968 and 1977, a decade with no executions, during which the constitutionality of the death penalty was being litigated. The largest number of executions in any one year since 1977 was the 98 executions in 1999. The largest number of executions in any one year in U.S. history is the 199 in 1935. Following 1999, there has been an uneven decline in the annual number of executions. Prior to the increase in executions between 2008 and 2009, the number of executions had decreased each year between 2005 and 2009. There were 52 executions in 2009, 46 executions in 2010, and on March 10th of this year, there have been 9 executions. Of the 1,243 executions since 1977, about 82% of them have been carried out in the South. About 12% in the Midwest, 5.6% in the West, and about 0.3% in the Northeast. Of the 1,243 executions since 1977, of the 34 death penalty states that have carried out at least one execution since 1977, half of them have executed fewer than 10 people. 3 death penalty jurisdictions have not executed anyone since executions resumed in 1977. Those 3 jurisdictions are Kansas, New Hampshire, and the U.S. military. Only 5 of the executing states account for 65% of the 1,243 executions. They are Texas, Virginia, Oklahoma, Florida, and Missouri. 3 of those states, Texas, Virginia, and Oklahoma, account for more than half of the 1,243 executions, 54% to be exact. Texas and Virginia account for approximately 46% of the total, and Texas alone accounts for 37.5% of the total. Texas accounted for about 49% of the 2008 U.S. executions, 45% of the 2009 executions, and 37% of the 2010 executions. In sum, except for a handful of countries in the world and a handful of states and counties in the United States, the death penalty is a dying practice. Clearly, those countries, states, and counties without a death penalty are able to administer justice and avoid calamities without a death penalty. So, why do we need the death penalty? Proponents of the death penalty proffer several reasons in support of its necessity. They include the unique deterrent value of the penalty, the unique incapacitating effect of the penalty, the cost of the penalty, the need for revenge, and the closure and psychological relief it provides victims' family and friends. Let's consider each of these reasons in turn. Death penalty proponents argue that the death penalty is a general deterrent for capital crimes. Some proponents argue that the death penalty is a general deterrent for all crime. General deterrence refers to the belief that people in general can be prevented from engaging in crime by punishing specific individuals and making examples of them. In the context of the death penalty, the broad deterrence question is whether or not executions prevent people other than the person executed from committing capital crimes. The late philosopher and death penalty proponent Ernest von den Hog explained why one should believe in the general deterrent effect of the death penalty. In the first place, he says, our penal system rests on the proposition that more severe penalties are more deterrent than less severe penalties. If this is true, he asserts, the corollary is that the most severe penalty, the death penalty, would have the greatest deterrent effect. He adds that arguments to the contrary assume either that capital crimes never are deterrable, sometimes because not all capital crimes have been deterred, or that beyond some point, the deterrent effect of added severity is necessarily zero. Professor von den Hog's first assumption, more severe penalties are more deterrent than less severe penalties, is generally correct. Beyond a point, though, added severity may reduce deterrence. In England during the 18th century, for example, there were about 150 capital crimes. Some put the number at more than 200. Many of the crimes were so petty that juries chose not to convict clearly guilty defendants rather than having to condemn them to die. This practice is called jury nullification. Such a practice likely reduces any general deterrent effect. Professor von den Hog's corollary, the most severe penalty, the death penalty, would have the greatest deterrent effect, is based on a debatable assumption and a testable proposition with no scientific evidence to support it. Is the death penalty the most severe penalty? For many it may be, but for others it may not. The prospect of spending the rest of one's life in prison may be more terrifying to some people than death, as it apparently was for Gary Gilmore, the first person executed following the resumption of executions in 1977. Gilmore goaded the state of Utah into executing him. Taking the opposite position to von den Hog, Cesar Beccaria, the 18th century philosopher whose ideas are the basis of much of the criminal justice process in the United States today, claimed that life imprisonment, he called it perpetual servitude, is probably a greater deterrent than death. Beccaria wrote, "To anyone raising the argument that perpetual servitude is as painful as death and therefore equally cruel, I will reply that adding up all the moments of unhappiness of servitude, it might well be even more cruel. But these are drawn out over an entire lifetime, while the pain of death exerts its whole force in a moment. And precisely this is the advantage of penal servitude, that it inspires terror in the spectator more than in the sufferer. For the former considers the entire sum of unhappy moments, while the latter is distracted from the thought of future misery by that of the present moment." Abolitionists maintain that the important question is not whether capital punishment is the severest punishment, but rather what punishment should be the severest allowed by law. Not all punishments are legally allowed. The United States Constitution prohibits cruel and unusual punishments. Even if it were agreed that the death penalty is the severest penalty, and that at least some capital crimes are deterrable. The problem remains that there is no scientific evidence showing conclusively that the death penalty has any marginal effect. That is, there is no evidence showing that capital punishment deters more than an alternative non-capital punishment, such as life imprisonment without opportunity of parole. Dozens of studies have examined the deterrent effect of the death penalty. The vast majority of them show that capital punishment makes no discernible difference on homicide or murder rates. Although we do not have time tonight to review in detail this vast body of research, let's consider the findings of one recent and very interesting study published in 2009 by law professor Franklin Zimmering and his colleagues. Taking advantage of a natural experiment, Professor Zimmering and his team compared execution and homicide rates in Singapore and Hong Kong. Hong Kong has conducted no executions since 1967. It officially abolished capital punishment in 1993. Singapore, on the other hand, had a relatively stable and low execution rate until the early 1990s, when it experienced a huge increase that peaked in 1994 through 1996. At their peaks, the execution risk for murder was 24 times higher in Singapore than in Texas. And Singapore gained the reputation of being the world execution capital. Over the next 10 years, Singapore's execution rate dropped by 92%. And by 2007, Singapore's execution rate was at its lowest level since 1981. Thus, Singapore's execution rate showed great variation during the study period. The peak rate in the mid-1990s was 35 times greater than the lowest rate in 2007. By contrast, Hong Kong's execution rate did not vary at all between 1981 and 2007 because it conducted no executions. And yet, as noted at the onset, the homicide trends for Singapore and Hong Kong were similar between 1972 and 2007. Neither the surge in Singapore's execution rate nor the steep decline in its execution rate affected Singapore's homicide rate. Nor, for that matter, did the absence of executions in Hong Kong affect that city's homicide rate. If executions were a deterrent to homicide, one might expect to see evidence of that effect in the world execution capital, but one does not. A major problem with deterrence theory as applied to the death penalty is the assumption that would-be capital offenders rationally calculate the consequences of their actions. Consider, for example, the many murderers who end up on death row because they killed someone during the course of an armed robbery. Many never intended to kill, but did so because of unexpected circumstances. Any who may have calculated the consequences of their actions before engaging in their crimes probably did not consider that the punishment might be death. And even if would-be killers knew that execution was the possible penalty for their actions, it likely would not deter them anyway. No more than 2% of criminal homicides each year result in an execution. The fact is, the chance of being executed for criminal homicide is very remote. Not only is there no evidence supporting a marginal deterrent effect for the death penalty, there is some evidence suggesting that the death penalty may have a counter-deterrent or brutalizing effect. In other words, the death penalty may actually cause murders rather than deter them. The idea that executions can provoke murders is an old one. And for years, psychiatrists have provided anecdotal evidence for such an effect. One variant is called the suicide murder syndrome, which is illustrated by the following example. Leslie B. Gareth was a 37-year-old businessman from Southern California. Not long after he hired Dorina Hammer, they began a torrid love affair. Unfortunately for the couple, Gareth's wife found out about the affair and tried to break it up, but to no avail. When Gareth asked his wife for a divorce so he could marry Dorina, his wife refused. Gareth became depressed and began to neglect the business and his family. Finally, Gareth and Dorina agreed to a suicide pact. They went to dinner and then went to a motel where Gareth fired 2 bullets through Dorina's heart. However, he could not kill himself. He telephoned the police, who came and arrested him. Gareth refused a lawyer, pleaded guilty to first-degree murder, and requested the death penalty. His request was granted, and he eagerly went to death knowing that he soon would be reacquainted with Dorina. In October 1998, Daniel Caldwell was sentenced to die in George's electric chair. Caldwell confessed that, unable to kill himself, he shot 2 strangers, Mitchell and Judith Bell, in a parking lot so the state would help him commit suicide. Diagnosed as a paranoid schizophrenic, Caldwell had been released from a mental health program just 2 days before he committed the 1996 murders. Finally, there is the case of John Blackwelder, who was executed in Florida on May 26, 2004. Blackwelder stated that he killed a fellow inmate so that he would get the death penalty because he couldn't stand the idea of spending the rest of his life in prison. And he could not commit suicide. Blackwelder was serving a sentence of life imprisonment with no opportunity of parole or a series of sex convictions. Another variant of the counter-deterrent or brutalizing effect has been termed the executioner syndrome. Those afflicted with the problem believe that killing performs a public service by eliminating a problem. Still another variant stems from the pathological desire to die by execution. Finally, from what is known about capital murderers, it is likely that some of them kill to gain the attention and notoriety that being executed might bring. Their executions provide them with a stage that would not be available to them under different circumstances. That certainly seems to be true about serial killer Danny Rawling, who was sentenced to die in 1994 for 5 murders, 3 rapes, and 3 burglaries in what became known as the Gainesville, Florida student murders. Rawling confessed he wanted to be a criminal superstar and the world's greatest rapist. The irony of all this is that although capital punishment has virtually no effect on crime, capital or otherwise, it continues to be a favored political silver bullet, a simplistic solution to the crime problem used by aspiring politicians and some law enforcement officials. A problem is that as long as politicians and law enforcement officials can gain political currency by perpetuating the belief in the death penalty's deterrent effect, attention will be diverted from more constructive, and it is hoped, more effective approaches to the prevention and control of violent behavior. This may yet be another way that capital punishment contributes to an increase in violent crime rather than the expected decrease. Death penalty proponents argue that the death penalty is necessary for its unique incapacitative effect. Incapacitation refers to preventing convicted murderers or other capital offenders from killing or committing other crimes again by executing them. Death penalty opponents concede that capital punishment permanently removes a threat to society, but they question whether such a drastic measure is necessary. They argue that if an alternative penalty such as life imprisonment without possibility of parole accomplishes the same purpose, it would be preferable because of the other costs associated with the death penalty. For example, a brutalizing effect, execution of innocent people, etc. Furthermore, to ensure that no convicted capital offender killed again, all convicted capital offenders would have to be executed. There are several problems with such a strategy. First, innocent people wrongfully convicted of capital crimes would be executed. If all convicted capital offenders were executed to prevent any one of them from killing again, it would be impossible to rectify the injustices done to the innocent people executed, their families and friends, and to a society that considered such acts immoral. At least 400 Americans were wrongly convicted of capital crimes punishable by death in the 20th century. And 138 Americans have been released from death row in 26 states because of evidence of their innocence since 1973 through March 29, 2011. And all of them would have died if the strategy was implemented. Perhaps as many as 24 capital offenders have been executed in air since executions resumed in 1977. To prevent such miscarriages of justice and still retain the death penalty, it would be necessary to identify convicted capital offenders who were innocent and spare them from death. This is no easy task because nearly all convicted capital offenders claim they are innocent, even though only a small percentage of them really are. Generally, it is only after considerable effort that proof of innocence is ever discovered, and rarely is such effort expended on death row inmates. For those family members and friends who would like to try, the financial and psychological resources necessary for such an endeavor are often not available. The risk of executing an innocent person is inherent in the process. Another reason not to execute all convicted capital offenders is that some of them will rehabilitate themselves while in prison and contribute to society. For example, San Quentin death row inmate and Crips street gang co-founder Stanley Tookie Williams was nominated for the 2001 Nobel Peace Prize. Williams, who was convicted in 1981 for killing 4 people, was nominated for his series of children's books, and his international peace efforts. His last book, entitled Life in Prison, describes daily life behind bars in San Quentin. It is targeted at 6th graders and intended to keep them out of street gangs. His internet project for street peace links at-risk California and South African youth through email and chat rooms. The project allows these youths to share their experiences and transform their lives. In 2005, Williams received a Presidential Call to Service Award from President Bush for his more than 4,000 hours of community service. In December 2005, Williams was executed. An alternative to capital punishment and another way to incapacitate capital offenders is true life imprisonment without possibility of parole, or LWOP for short. LWOP also eliminates entirely the possibility of executing an innocent person and allows some capital offenders to rehabilitate themselves and make positive contributions to society. Currently, all death penalty jurisdictions in the United States have the LWOP alternative. Death penalty proponents claim that LWOP is too expensive, that it costs much more to imprison an offender for life than it does to execute him or her. This is another reason that the death penalty is presumably necessary. If those death penalty proponents have in mind only the costs of the eventual execution, they are right. And execution is cheaper than LWOP. But if they consider the entire process of capital punishment, including trials, appeals, and executions, then they are wrong. The Supreme Court requires that defendants charged with capital crimes be provided with what has been called super due process. And super due process is expensive. Time does not permit me to go into detail about the cost of the death penalty process, but consider the following. The death penalty costs California taxpayers $137 million a year, compared to only $11.5 million per year for a comparable system that sentenced the same inmates to LWOP. Because California has executed only 13 people since it reinstated the death penalty in 1977, the cost for each execution is more than $250 million. The state has indicated that it needs $400 million for a new death row. New Jersey's death penalty cost taxpayers at least $253 million since 1983, approximately $11 million a year, even though New Jersey had not executed anyone during that period. The $253 million is over and above the costs that would have been incurred had the state utilized a sentence of life without parole instead of death. Since 1982 and through the end of 2005, New Jersey had conducted 197 capital trials and had imposed 60 death sentences, of which 50 were reversed. At the end of 2004, it was estimated that it took $2.3 million to $3.2 million to pursue a death prosecution in New Jersey. As noted previously, New Jersey abolished its death penalty in 2007. In the state of Washington, between 1993 and 2003, a death penalty trial cost on average $432,000. That was more than twice as much as the average $153,000 cost of a non-death penalty trial. In 2003, the average cost of a death penalty case in Kansas was $1.2 million. A life without parole sentence could save Kansas taxpayers between $400,000 and $500,000 per trial. In Maryland, the estimated extra cost to taxpayers for each death penalty case prosecuted between 1978 and 1999 was $186 million. Based on the 5 executions conducted during that period, the cost per execution was $37 million. In 2009, the New Hampshire Commission to Study the Death Penalty held a hearing in Concord, which I'm told is just up the road, to examine the cost of the death penalty. Deputy Attorney General Orville Fitch testified that the state spent more than $5.3 million on 2 capital cases that year, even though the state has not held an execution since 1939. The state spent $1.6 million to prosecute Michael Addison, who was ultimately sentenced to death. The state spent an additional $1.2 million for the public defender who represented Addison. It typically costs $70,000 to $100,000 to defend a defendant charged with first-degree murder. The Attorney General's office also spent $2.4 million prosecuting another defendant in a murder-for-hire case in which a life sentence was returned. The average cost per execution in the United States, that is, the entire process, is estimated to range from about $2.5 million to $5 million, and that's in year 2000 dollars. Now, extraordinary cases can cost much more. For example, the state of Florida reportedly spent $10 million to execute serial murderer Ted Bundy in 1989. Orange County, California spent more than $10 million just to convict serial killer Randy Kraft that same year. 22 years later, Kraft remains on California's death row awaiting execution. Finally, the federal government spent more than $100 million to execute mass murderer Timothy McVeigh in 2001. On the other hand, the cost of an LWOP sentence is roughly $1 million, making the death penalty on average about 2.5 to 5 times more expensive than LWOP. Another consideration is that death penalty costs are accrued up front, especially at trial and for the early appeals, while life in prison costs are spread out over many decades. $1 million spent today is a lot more costly to the state than $1 million that can be paid gradually over 40 years. Also remember that whenever a capital trial does not result in a death sentence and execution, as has been the case in New Hampshire, the added costs associated with the death penalty process have been incurred without any return on the state's investment of resources. In other words, the enormous costs of capital punishment are not a product of the number of executions, but rather the number of people death penalty jurisdictions attempt to execute. Also worthy of note is that the death penalty's availability creates a pressure to seek it that is difficult to resist and would not exist in its absence. As Professor Herbert Haynes explains, how is a prosecutor to explain to a grieving family why he or she decided to seek death for another accused murderer, but not for the killer of their loved one? How is he or she to apply it sparingly, knowing that his or her opponent in some future election will accuse him or her of being soft on criminals? Elected officials striving to appear moderate sometimes call for limited death penalty laws intended only for the worst of the worst killers. But limited death penalties beg to be expanded, especially in election years. Capital punishment then often seems to have a built-in momentum that demands that it be used, and that drives up its cost. The evidence clearly shows that capital punishment systems in the United States are always more expensive than punishment systems without capital punishment, because super due process is required in the former, but not in the latter. It really is water. Death penalty proponents contend that the death penalty is necessary to meet the need for revenge. Revenge for death-eligible crimes is an emotional, though quite understandable reaction. A problem with revenge as a justification for the death penalty is that a decision as important as the intentional taking of a life by the state should be based more on reason than on emotion. Opponents of the death penalty point out that it is largely emotion that makes people want to punish in kind. As the father of a murder victim expressed it, for many months after the Oklahoma City bombing, I could have killed Timothy McVeigh myself. Temporary insanity is real, and I have lived it. You can't think of enough adjectives to describe the rage, revenge, and the hate I felt. As for punishing in kind, no other crime is punished in kind. The literal interpretation of the eye for an eye maxim is not imposed for any other offense. For example, the state does not burn down the houses of arsonists, cheat people who defraud, or rape people who rape. Why then, opponents ask, is it necessary to kill people who kill? Their answer is that it is not. In practice, only a select few among all those who are death eligible are executed in the name of revenge. However, even if one assumes that revenge is a legitimate rationale, opponents of the death penalty argue that there is no reason why revenge could not be served by another non-capital punishment, such as elbow. On this point rests what may be the quintessential difference between proponents and opponents of the death penalty. Proponents sometimes misunderstand that opponents of the penalty do not want capital offenders to escape punishment or justice. Indeed, most of them want such offenders to be punished to the severest degree allowed by law. The only difference between the two groups is what the severest punishment allowed by law should be. Some death penalty proponents maintain that by allowing the state to seek revenge, relatives and friends of the victim are relieved of the need to do so. An implication is that with the abolition of the death penalty, relatives and friends of a victim are more likely to seek personal revenge. However, as U.S. Supreme Court Justice William Brennan observed, there is no evidence whatever that utilization of imprisonment rather than death encourages private blood feuds and other disorders. During the hiatus in capital punishment in the United States between 1968 and 1977, there was no apparent increase in personal revenge. Nor do states without capital punishment have elevated levels of personal revenge. The 139 countries that have abolished capital punishment in law or practice suffer no apparent problems either. This seems proof that a need for revenge can be satisfied by an alternative punishment such as life imprisonment. Death penalty proponents cite retributive grounds in suggesting that legal vengeance is a way of enhancing social solidarity and of sanctifying the importance of innocent life. Assuming the argument has merit, there would seem to be other ways than capital punishment of achieving those ends. For example, non-capital punishments, or better yet, more positive measures. Moreover, it is difficult to understand how the taking of a life, even of a person guilty of a capital murder, in any way sanctifies life. Henry Schwarzschild, the former director of the Capital Punishment Project of the American Civil Liberties Union, asked, "How can a thoughtful and sensible person justify killing people who kill people to teach that killing is wrong?" A related reason the death penalty is necessary, according to death penalty proponents, is that it provides closure to a victim's family and friends. However, whether executions provide such co-victims closure is a controversial issue. On one hand, describing his decision to grant clemency to all Illinois death row inmates following discussions with co-victims, former Illinois Governor George Ryan said, "To a family, they talked about closure. They pleaded with me to allow the state to kill an inmate in its name to provide the families with closure." On the other hand, many capital crime victim family members, including some who support capital punishment, state that executions produce an outcome, but never closure. As the daughter of a murder victim explained, "I get sick when death penalty advocates self-righteously prescribe execution to treat the wounds we live with after homicide. Those who hold out an event, an execution, as a solution to pain have no understanding of healing. Healing is a process, not an event." Similarly, the mother of a murder victim complains, "I don't know why the powers that be have come up with the word closure. There is no closure, and there never will be." Law professor Franklin Zimmerman maintains that in the past couple of decades, closure has replaced revenge as a primary purpose of capital punishment. It was not until 1989 he discovered that the term closure was first used by the printed mass media to describe a major objective of the death penalty. This symbolic and linguistic shift in emphasis from revenge to closure, according to Zimring, has been a public relations godsend for death penalty proponents that has transformed capital trials and executions, at least in the minds of the public, into politically palatable processes that serve the personal interests of homicide survivors. He observes that the penalty stage of death penalty trials, for example, has become a status competition between the offender and those who were injured by the crime. This shift in rhetoric has been especially important in retaining the support of people who distrust government, because for them it is much easier to support executions as a public service, such as garbage collection or street cleaning, than it is to contend with arguments that executions represent the excessive use of power by and for the government. Some death penalty proponents argue that life imprisonment or a lesser punishment rather than execution may not provide the psychological relief deserved by victims suffering survivors. For some families, anything less than an execution may be taken as a slight, an indication that society does not value their relative or understand the magnitude of their loss. For them, it's unfair that their loved one's killer will continue to experience many of the small joys of life, such as seeing the sun rise and set, celebrating birthdays, experiencing Christmases, and visiting with loved ones, while their loved one cannot. Death penalty opponents respond in at least two ways. First, death penalty opponents note that the family member and friends of many criminal homicide victims are likely to be disappointed and in many cases offended by the justice they receive. Few of them will receive any of the presumed benefits of capital punishment because 98 to 99% of criminal homicide offenders are never executed. In the vast majority of criminal homicide, a death sentence is not even sought. Thus, many homicide victims' family members and friends will feel that they and the homicide victim are unworthy and have been devalued by the justice system because the killer of their loved one or friend did not receive the maximum punishment allowed by law. Second, death penalty opponents point out that even if an execution did make a loss easier to endure for the victim's relatives and friends, that advantage would have to be weighed against the effects of the execution on the perpetrator's relatives and friends. Research shows that the effects of capital punishment on death row or executed inmates' families and friends can be as profound, or in some cases more profound, than it is for the victim's family and friends. Thus, if the death penalty does not have unique deterrent value, if it does not have a unique incapacitative effect, if it costs more than an alternative punishment such as life imprisonment without opportunity of parole, if it is not needed to satisfy the desire for revenge, and if it does not provide closure or psychological relief to most victims' family and friends, then why do we need the death penalty? Before I conclude my presentation this evening, I think it is important to at least briefly consider some additional problems with the death penalty that further invalidate any need for the sanction. I have already mentioned that the death penalty may have a counter-deterring or brutalizing effect, that it is used by politicians for purely political and disingenuous reasons, that innocent people are wrongly convicted and executed, that it costs more to administer than an alternative punishment such as life imprisonment without opportunity of parole, that it can be insulting to victims' families and friends when it is not imposed, as is the case in 98 to 99% of all capital crimes, and that it causes unbearable hardships to the families and friends of death row and executed inmates. Two other problems with the death penalty are that it continues to be employed in a constitutionally impermissible, arbitrary, and discriminatory way. Two of the reasons that the U.S. Supreme Court invalidated the death penalty in the landmark decision of Furman versus Georgia in 1972 were that the death penalty had been imposed in an arbitrary and discriminatory way. Arbitrary application refers to random application. The death penalty system is a lottery. As mentioned previously, only 1 to 2% of all death-eligible offenders have been executed from 1930 to the present. Thus, not only is the vast majority of capital offenders able to escape execution, but there is no meaningful way to distinguish between the eligible offenders who were executed and those who were not. Even during the peak of executions in the United States in the 1930s, only 20% of all death-eligible offenders were executed. One might assume that the few death-eligible offenders that are executed represent the worst of the worst. But the worst of the worst sometimes escape execution, while murderers who clearly are not among the worst of the worst do not. For example, in 2003, Gary Ridgway, the so-called Green River Killer, admitted to killing 48 women during a span of 2 decades. He was allowed to escape the death penalty by pleading guilty to the murders, and in doing so gained the distinction of pleading guilty to more murders than any other serial killer in American history. He was sentenced to consecutive life sentences without opportunity of parole for each murder. The prosecutor reluctantly agreed to the plea deal because investigators and victims' relatives wanted the murders resolved and cases closed. Had the victims not been prostitutes, drug addicts, and runaways, perhaps the prosecutor's decision might have been different. Arbitrariness is also evident in the way the death penalty has been applied across jurisdictions and over time, as indicated by my earlier discussion of the application of the death penalty in different states and counties. The death penalty appears to be not an integral part of the criminal justice process in most of those states and counties, but an occasional product of chance and unpredictable occurrence. The death penalty also continues to be employed in a constitutionally impermissible discriminatory way. The death penalty is reserved almost exclusively for the poor, for men, and for killers 18 years of age and older. It is also imposed disproportionately on black males and the killers of white victims. The wealthy are practically immune to the death penalty. As Attorney Brian Stevenson has pointed out, capital punishment really means them without the capital gets the punishment. A major reason wealth matters is that the wealthy are able to hire the best attorneys. In many capital cases, the outcome depends more on an attorney's skill than what actually happened. The death penalty is rarely inflicted on women, even though women commit roughly 1 in 10 of all criminal homicides. Since 1976, women have received about 2% of all death sentences. Only 12 women have been executed since 1976, compared to 1,231 men. It has been estimated that under current death penalty laws, if women and men were treated equally, and that no factor other than offense was considered, women would receive between 2 and 3 times more death sentences. About 2% of all people executed in the United States have been juveniles. That is, individuals who committed their capital crimes prior to their 18th birthdays. In 2005, in the case of Robert versus Simmons, the United States Supreme Court ruled that the U.S. Constitution's 8th and 14th Amendments prohibits the execution of capital offenders under the age of 18. However, while the practice existed, juveniles, like women, were filtered from the process. Only 22 juveniles, all but one of whom were 17 years old at the time they committed their crimes, have been executed since 1976. The one exception was 16 years old. What makes the current practice of excluding death-eligible juveniles from the death penalty discriminatory is that the designation of juvenile is arbitrary. Is there a significant difference on any relevant social characteristic between a 17-year-old and an 18-year-old, other than what has been created by law? Is it really meaningful to consider a 17-year-old a juvenile and an 18-year-old an adult? The Simmons decision did nothing more than change the age at which death penalty states are allowed to discriminate. Black males are also victims of discrimination in the administration of the death penalty. For example, from 1800 to the present, about 50% of all persons executed in the United States have been African Americans, even though they comprised only about 11 to 13% of the population. From the early 18th century through the mid-20th century, African American execution rates were on average about 9 times higher than white execution rates. According to an evaluation synthesis of 28 studies conducted since 1976, prepared by the U.S. General Accounting Office, the GAO, and published in 1990, more than half of the studies found that race of defendant influenced the likelihood of being charged with a capital crime or receiving the death penalty. And in more than 3/4 of the studies that identified a race of defendant effect, black defendants were more likely to receive the death penalty. An update of the GAO study prepared by the American Bar Association showed that in nearly half of the death penalty states, race of defendant was a significant predictor of who would receive a death sentence. In all but 2 of those states, Florida and Tennessee, black defendants were more likely to receive a death sentence. Finally, a second, less obvious form of racial discrimination is victim-based racial discrimination. Whether the death penalty is imposed depends on the race of the victim. Research shows that killers of whites, regardless of their race, are much more likely to be sentenced to death than are the killers of non-whites. killers of white females, particularly if the victim had been degraded and humiliated. On the other hand, the killers of black male victims are the least likely to be sentenced to death. The ABA study just mentioned found evidence of race of victim disparities in 93% of death penalty states. And in all but one of those states, Delaware, white victim cases were more likely to receive death sentences. Recent data revealed that 80% of the victims of those persons executed since 1976 have been white, and that only 13% have been black. Yet 56% of defendants executed have been white, and 35% have been black. Discrimination seems apparent because historically, capital crimes have generally been intra-racial. For example, in 2009, white offenders murdered 84% of white victims, and black offenders murdered 91% of black victims. Still, some uncertainty remains about whether the data show discrimination, because only about 20% of murders are capital crimes, and a much larger proportion of white victim murders may be capital murders. They're certainly treated that way. In sum, there are really no good reasons for supporting the death penalty over an alternative punishment, such as life imprisonment without opportunity of parole. And there are plenty of good reasons to oppose the death penalty. So let me end my presentation where I began, by asking this question: why do we need the death penalty? Thank you.